Today we're going to talk about risk of loss, and this is a concept that I've mentioned in passing for the past couple of weeks. The idea here is what happens when goods are somehow lost or damaged? Who bears the cost? And as you might imagine, a lot of this analysis goes along with who's responsible to care for the goods. And so a lot of what we'll be talking about is risk of loss in shipment, but we'll also look at, in the cases and problems for assignment 20, what happens when the buyer, for instance, might be in possession of the goods but has already given notice to the seller that the goods are non-conforming. Who bears the risk of loss for injury to the goods, damages to the goods in those cases? So what does it matter? What do we really mean when we say risk of loss? It's who's going to eat the cost of those goods. Does the seller have to send replacement goods and absorb the cost of the original goods that were lost? Does the buyer have to deal with the lost goods or damaged goods by going after the carrier who somehow lost or damaged the goods? And I think by the end of our discussion, both in this video and then in the problems, you'll come to the conclusion that it is really important to have good insurance. When I talk about deliveries, right, what am I talking about? Well, there's lots of ways that a seller can deliver, can get the goods to the buyer. Common ones are a third-party common carrier, UPS, FedEx, the Postal Service. Then there is a third-party bailee. In other words, you, as the seller, will bring the goods to, say, a refrigerated storage facility, right? And then the buyer can pick them up from there. And then there are the occasions when a buyer might pick up directly from the seller. So the buyer might have their own shipping fleet, for instance, and might send a truck to the seller to pick up the goods from the seller's warehouse and take those goods back to the buyer. I am not going to go into a lot of detail in this class about the instruments that are used to ship goods either domestically or internationally, but I do want to introduce you to the concept of something like a bill of lading. All right, so when people talk about a bill of lading, this is the kind of thing that they're discussing, which is a way for the buyer, the seller, and third-party carriers to keep track of goods. Right. A lot of this can be done electronically now, but the paperwork is still used. It's still important, and it allows all of the people who are handling goods to understand who has it at what time. So the basic rules for situations where goods are damaged in transit involve trying to figure out when the responsibility, the risk of loss, passes from the seller to the buyer. So the basics are, if a particular party is at fault for the loss, then that is the party who must bear it. If you could make the argument perhaps that the goods were inadequately packaged and that's why they didn't make the journey damage-free, then perhaps you could have an argument that the seller could be responsible for the cost of that loss, even if the actual ownership and delivery had already been tendered, had already transferred to the buyer. Otherwise, you have to figure out at the time that the damage or loss occurred, who was the party that bore the risk. Right? And so we'll talk about some UCC defaults. Keep in mind, you can always contractually specify who bears responsibility, who bears the risk of loss for the goods at any point in the transit. And then realistically what happens is most buyers and sellers, at least commercial ones, carry insurance for their goods. And so at that point, you have insurance companies who are fighting it out to say, yes, we should have to pay this. No, we shouldn't. Okay, we paid our client. Now we're coming after you under subrogation. So really what ends up happening a lot of the times is that we have insurance companies fighting things out. Here are the sort of big risk of loss terms that I want you to be aware of. This is the kind of stuff that you're going to see if they're testing, say, risk of loss on a bar exam. Right? There are many interrelated provisions dealing with risk of loss. So again, this is a high-level simplification. All right. Free on board seller, free on board buyer. All right. Free on board seller is sometimes called a shipment contract. And what that means is that the risk of loss passes to the buyer pretty much as soon as the goods have been shipped from the seller. All right, so upon seller's delivery of the goods to a common carrier, UPS, at that point, the risk of loss shifts to the buyer. And so free on board seller, or free on board, and then it might say point of shipment. So if the seller is located in Detroit, and it says FOB Detroit, then you know that's a shipment contract. Some other things to keep in mind. Okay. The shipment contract, that's the UCC default. And so when you're looking at those gap fillers and default terms in Section 3 of Article 2, right, you're going to see that the default in 2308 is FOB seller. What does it mean for a seller to deliver goods to a carrier? Right? The seller gives the carrier the goods with a reasonable transportation contract and documentation for the goods, and the seller has to notify the buyer of shipment. You're probably very familiar with this, right? That once your goods have shipped, nowadays you just get an email that says, notice, goods have shipped. All right, so this is the default, FOB seller. Then the other main way of passing risk of loss is a destination contract. And so FOB buyer, FOB the destination. So let's say you're shipping goods from Detroit to Lansing. All right, if it says FOB Lansing, then that means that the risk of loss is going to remain with the seller until those goods make it to the buyer in Lansing. So the seller must tender the goods to the buyer, and we've talked a little bit about tender before, but essentially the buyer has to be able to take possession of the goods and get any necessary notice and documents, like those bill of lading I was mentioning, from the seller. So if you're gonna bookmark something for your future bar study, this is really the basics of what you need to know. Shipment contracts, destination contracts, what it means to be FOB seller or FOB buyer. I did not assign you the reading on leases. Right? Typically with leases of goods, the risk of loss stays with the lessor. As you might guess at this point in the semester, when does the risk of loss pass to the lessee? Yep, that's right, finance leases. Okay. We're going to talk a little bit now about international sales. And I'm going to talk about something called international commercial terms, or Incoterms. And I would really encourage you in your future practice, if you find yourself looking at some sort of international shipping contract with a bunch of three-letter acronyms, to remind yourself, oh yes, there are these things called Incoterms, and I should be thinking about them. So I'm actually going to jump ahead to talk a little bit about these Incoterms. The reason I like this graphic is because I think it does a really nice job of showing you what actually all is involved in international sales of goods. All right, because you have to deal with all of your sort of export duties and with shipping, with somehow getting the goods over an ocean, whether that is on a shipment vessel, whether that's on an airplane. Then, once they get to the destination country, they somehow have to be unloaded from the airplane or the ship onto some other means of transport, a truck, a train, and then carried to the destination. And, at some point along the way there, somebody's going to be responsible for paying customs and taxes and duties on the buyer's end. And so the free on board shipping point, right, is essentially what you see up near the top where it says FCA shipping point, which is more or less saying the seller is responsible basically just as far as getting it to the carrier. There's one called CPT, which I highlight a few down, which is similar, right? It's here, the idea is that the seller's responsible up to the point of getting it to the other country at the port of import, and then the risk is shifting to the buyer at that point once it's been loaded onto a carrier in their buyer's country. Right. Then towards the very bottom, right, it's called DAP. You see it in the bottom. You see the flip side, the destination contract, right, where the seller keeps that responsibility up to the place of destination. Right. So here the seller isn't paying the taxes in the buyer's country, but the seller is keeping this risk of loss up to getting the goods to the buyer. So I think this is a useful mental map. And obviously if you're dealing with international shipping, I think you'll want to keep these in mind. All right, briefly, want to talk about our cases for today. And I'll click so this stops going back and forth. Maybe, I don't know. Okay, so in our Stampede presentation products case, this sort of feels like maybe if the deal is too good to be true, it probably is. So the plaintiff, Stampede, buys over $200,000 worth of TVs from the one sale a day on a free on board origin or a shipment contract. The plaintiff's carrier, Productive, arranged for a subcontractor, MML, to pick up the TVs. But apparently the TVs were picked up by another party who happened to have a document, the bill of lading, that seemed to indicate that they were authorized to pick up the TVs, and the TVs never made it to the plaintiff. and ultimately it was plaintiff's customer. The plaintiff was reselling the TVs to somebody else. And unfortunately, the plaintiff had paid one sale a day in advance. All right, so the seller wasn't about to give them their money back. So there's claims here of negligence, breach of contract, unjust enrichment, and the question, the negligence question, essentially is, was the seller negligent in delivering the goods to the carrier such that the seller never properly delivered the goods? All right, so were they so negligent that they didn't actually deliver the TVs at all? Court walks through the basic UC analysis. Shipment contracts are governed by UCC 2504. Is this a shipment contract or a destination contract? Right, they need to figure that out. Right. They talk about how one sale a day says, well, this is a shipment contract. The risk of loss or damage to the good passes from the seller to the buyer upon delivery of the goods to the carrier. Right? It gives you the UCC 2504 definition. In contrast, they explain a destination contract, which would be covered by 2503, arises where the seller is required to deliver at a particular destination. So the court looks at the contract, right? And they say, well, looking at this document and considering what they describe as the undisputed logistics of the transaction, it's clear that the contractual arrangement required or authorized one sale a day to ship the TVs by carrier designated by Stampede to be productive transportation. Okay. There's no requirement to deliver the TVs to a particular destination. There's no requirement to make sure that the TVs even get to the destination. Right? The invoice simply identifies them as one sale a day as the vendor, directs that the purchased items are to be shipped to the resale customer in Naperville, Illinois. Right? And so, looking at the terms, it seems like this is sort of your standard free on board seller. Okay. So who bears the risk of loss in this case? In a shipment contract, in a FOB seller, the buyer bears the risk of loss once the goods have been delivered to the common carrier. Right? Well, what about that claim that the seller was negligent in delivering the goods, right, to the carrier? Right? Well, they say Stampede, the plaintiff, was the one responsible for arranging the carrier for the goods. And there wasn't any sort of additional independent duty from the seller's standpoint to vet the common carrier. It seemed as though the common carrier had the necessary documentation. Then there's this argument of unjust enrichment for the seller, right? Or the idea here being that the seller has the money, the buyer, or really the buyer's customer, doesn't have the TVs. Well, okay, that the court points out, typically we use unjust enrichment when we find that there's no contract. That's not what we're finding here. We're finding that there is a contract and that the seller met their obligations under the contract, so the seller's not in breach at all. So they recognize that there was a benefit conferred, but ultimately it's not the seller's responsibility for what happened here. And so that's one reason why risk of loss is important. Right? It's who does the buyer have a remedy against. And here it's not the seller, because the seller's obligations ended when they delivered, and here they say, the court says not negligently, to the carrier. All right. So let's talk a little bit about our next case as well. So in this case, we have a plaintiff, Cook Specialty, and who's the buyer, and our defendant MSL was the seller. So the seller, MSI, contracted to sell Cook a hydraulic brake pump that was lost in transit, right? Supposedly fell off the truck that was being used to transport the goods. And in this case, despite the contract being a free on board seller contract, right, which would typically mean that the risk of loss would pass to the buyer as soon as the seller gets the goods onto the common carrier, the argument that the buyer here is making is that the risk of loss did not shift to the buyer at shipment because the seller's contract with their carrier was not reasonable. Essentially, the issue here was that the carrier, they think, was not adequately insured. And so the Illinois State Police cited the carrier's truck for not properly securing the load. Plaintiff by this point has recovered some damages from the carrier's insurer, right, but only was able to recover $5,000, which was the policy limit for this incident, from the carrier's insurer, and the machine was worth $28,000. So that's essentially their argument, is that you needed to make sure, seller, that the carrier that you used was insured up to the amount of the goods, so that if they did lose the goods, we would get our full recovery as the buyer. The court walks through a number of considerations that you should think about in asking, did the seller have a reasonable contract? Did the seller properly set up their contract with the common carrier in an FOB seller? So did the seller agree to insure the products and then fail to do so? All right, so was there an actual agreement that the seller was somehow responsible for the insurance? Did the seller ship at a cut rate or a lower rate than agreed upon? And so does it seem like the seller is cutting corners or is being, unnecessarily cheap about things? Did the seller make the packaging theft tempting? All right, so they give examples of cases where it says on the box what the thing is, which makes it tempting if, say, you were to leave it on somebody's doorstep, that somebody might come and take the goods. You'll notice often when you buy things online, you will get a little notice that says that something like goods come in their original packaging, right? If they're not in sort of an anonymous box. And that is sort of the seller doing their diligence and trying to cover themselves by giving you notice. You need to be tracking this package carefully, buyer, because it is theft tempting, essentially. Did the seller agree to an inadequate valuation of the goods being shipped? So they give some examples of cases where the seller, in an attempt to sort of save on the shipping costs or save on the insurance costs, deliberately states a lower value for what the goods are worth. And it seems like in this situation, the seller didn't do any of those things. And ultimately, the court says that it's not reasonable on the part of the seller to inquire as to insurance coverage by the carrier, And so the seller's contract with the carrier was acceptable. The risk of loss lay with the buyer, with FOB seller, which is the default. I would just encourage you, especially if you're working with a big company, right, there's going to be a lot more quality control and compliance measures in place. And so likely you are going to be working with carriers that are adequately insured, but it's never a bad thing to ask when you're using a common carrier, especially perhaps a more localized one, what their insurance coverages are. You would certainly do the same thing if, say, you were using a moving company to move your own personal goods. And then as a seller, I think it's still a good lesson to make that inquiry of your carriers. Okay, that is it in terms of our cases for today. A few words about some special risk of loss cases. So when we are dealing with bailees, right, somebody who's holding the goods, a reminder that the risk of loss shifts to the buyer, right? Essentially, when the buyer gets the documents of title that say, hey, buyer, these are your goods, go pick them up from the bailee, right? Or in some other way, the bailee acknowledges the buyer's right of possession by giving the buyer the goods, or the buyer tells the bailee, hey, you're holding these goods for me at your warehouse, here's how you need to deliver them to me. Now, what do we do if we're dealing with a direct transfer of the goods between the seller and the buyer? Because most of the tricky cases we've been talking about involve some third body, some third person in the middle. So if we're talking about a merchant seller, right, the risk of loss shifts to the buyer upon receipt of the goods. Right. So once the buyer's there, picks up the goods from the merchant, the risk of loss shifts to the buyer. Right. Keep in mind that what this means is that if the seller is holding the goods for pickup, the risk stays with the seller until the buyer actually has the goods. And if we're talking about a non-merchant seller, then the loss shifts to the buyer upon tender of delivery. Right? So here it sort of shifts the presumption. If the seller is holding the goods for the buyer to pick up, the risk lies with the buyer. Our cases for today will also allow us to walk through Section 2510, right? This idea of the effective breach on risk of loss. But the basics here is that when the buyer rejects the goods, right, then it's as if the risk of loss had remained with the seller the whole time. If a buyer revokes the goods, revokes acceptance, remember that happens a little bit later down the chain, right? There, the UCC says the buyer may, to the extent of any deficiency in his effective insurance coverage, treat the risk of loss as having rested on the seller from the beginning. So in that case, it's if something happens to the goods and buyer's insurance doesn't cover that loss, then the buyer can go after the seller, right, for some of that additional costs. And then, sort of a probably less common scenario, but could theoretically happen, where the buyer has essentially repudiated goods that are already identified, right, before the risk of their loss has passed to the buyer, In that case, if something goes wrong and seller's insurance doesn't cover it, then seller can go after the buyer. All right, so that's 2, 5, 10, and we'll work through that in our problems for class discussion. So I will see you dark and late on Thursday to talk about risk of loss.